Welcome back to Let's Talk Employment Law. This is an employment podcast brought to you by the Neave employment team. My name is Elise Wilson and I am a solicitor in the Christchurch office, and today I'm joined by Senior Associate Hannah Martin. We do wish to note that these podcasts are general in nature, and if you require any specific advice, we do recommend that you get in touch and you do not rely solely on these episodes. In today's episode, we're going to be having a talk about your legal requirements as an employer for employees who are pregnant in your workforce. In New Zealand today, majority of employees who are pregnant are also working, and so it's important to make sure that you know what your obligations are here and that you feel comfortable with managing these employees while they're in your employment.
Yeah, absolutely, and it is unfortunate, but even in today's day and age, pregnant employees are still facing varying degrees of discrimination in the workplace, whether that be directly or indirectly. Pregnancy discrimination is obviously a form of sex discrimination, and the Human Rights Act 1993 makes it unlawful to discriminate against an employee or a job applicant because they're pregnant or they assume to want to become pregnant, so i.e. they're a female. The Employment Relations Act also contains similar provisions, and in addition to that, Section 49 of the Parental Leave and Employment Protection Act states it's illegal to dismiss an employee for being pregnant, applying for parental leave, or being on parental leave. So if an employee feels that they have been discriminated on any of those grounds, they have a couple of options available to them. They can either make a complaint to the Human Rights Review Tribunal and the Commissioner, or they can raise a personal grievance against their employer. In addition, the Parental Leave and Employment Protection Act states that a labour inspector can commence an investigation into a complaint which relates to discrimination on those grounds, and ultimately the Employment Relations Authority can hear a complaint as well and provide a remedy on the basis of that act. So it might seem straightforward. Some examples of discrimination include refusing to hire or promote someone because they're pregnant or going on parental leave, making derogatory remarks, refusing to include them in training, demotion, and obviously just outright firing or dismissing that employee. That includes doing it constructively in terms of pushing them out of their business as well.
Thanks for that, Hannah. It's really important to be aware of that, and also, like you said, to make sure that indirect discrimination is not happening as well as direct discrimination. Another point to note while employees are on work, there may be some instances where employees who are pregnant are actually unable to safely do their role. And in these instances, the Parental Leave Act does actually provide for them a remedy to this. So under Section 16, as an employer, you can instigate a temporary transfer of duties of the employee. And so this means that the employee can be transferred to a different role that is safe for them to perform. So for example, you might have an employee who does a lot of manual lifting in their role, but through their pregnancy that becomes unsafe for them. And so you can transfer their duties to possibly some administrative tasks or tasks where they can be seated. And so to do this, you need to make sure that you consult with the employee. It needs to be done in collaboration with them and not be something that you simply just tell them. So the employee needs to be consulted, and it's also really important to make sure that any transfer does not negatively impact on the rights that the employee has. So it can't negatively impact their hours of work or the pay that they receive, or put them on any terms of employment that are less favourable than what they already were on. So we do recommend that seeking advice over this process is best to make sure that you're getting it done properly and also in line with your good faith obligations.
Yeah, so basically it's the same as making any substantial change to someone's role or any change that's going to affect them. It requires a period of consultation. Just because you think you might be doing it in their best interests, it doesn't necessarily mean you need to skip that important process in employment law. That transfer point is also really important, I think. Lots of people might not be aware of it. But again, that consultation point is really important. There are some other practical ways that you could make your employees feel more comfortable, your pregnant employees feel more comfortable at work. Basically anything that makes them more comfortable would be welcomed, just from experience. But this includes sort of making sure that their seating or working stations are comfortable. If they stand to do the job, can they sit to do it? Can you provide them with a temporary car parking space or give them more opportunities to eat or drink? Can you discuss the possibility of flexible working with them? These are some practical suggestions. They're not legal requirements, but they do go a long way to improve an employment relationship. Obviously, again, we understand that employers have to work within their means, so not all particularly financial additional entitlements are possible for everyone. But if you think outside the box and think about the practical things you can do to help your employees, and that'll go a long way.
Thanks, Hannah. And along with that, it's also important for employers to be aware of their obligations under the Health and Safety at Work Act. And so this act requires that employers do everything that is reasonably practical to ensure a safe and healthy work environment. And so we recommend that when employees are pregnant in the workplace, that a risk assessment is done of their role to make sure that it is being carried out safely. Because while they're in the workplace, you do need to make sure that there's no risks or hazards that could harm them. And sometimes when employees are pregnant, it can heighten some of those risks in the workplace. So it's important to make sure that an assessment is done of these and any practical steps are carried out.
Yeah, thanks, Elise. That could include just getting someone to come along to assess the ergonomics of someone's desk and seating position, because the way they hold themselves do change when they're pregnant. And I do think that it's also really important to keep in mind that if you are going to carry out a risk assessment under the Health and Safety Act and you have nothing but good intentions, you want to do it in a way that doesn't really make that person sort of stick out and feel uncomfortable and picked on because they are pregnant, because then you're sort of teetering on the edge of a potential discrimination claim. And while it's not discrimination, you don't want to make someone feel like they have been discriminated against. Just finally, the Act does contain some procedural and notice requirements on employees and employers in terms of the taking of leave. So for example, at least 3 months before an employee goes on parental leave, they need to advise their employer in writing of the type of leave they want to take and for how long they plan to be away from the workplace. These are pretty technical aspects. If you require information on your obligations, please don't hesitate to get in touch.
Great, thanks for that, Hannah, and thank you so much for joining us in this episode where we've taken a look at your legal obligations but also some practical steps that should be taken to support pregnant employees in your workplace. We hope that you've found this episode useful, and in the next episode we are going to be taking a look at your legal requirements while employees are on their parental leave.